I'm Adam Winkler. I'm a professor of law at UCLA School of Law here in Los Angeles and the author of Gunfight, The Battle of the Right to Bear Arms in America. McDonald against City of Chicago was the follow-up case to District of Columbia against Heller. In the Heller case, the Supreme Court said the Second Amendment limits the ability of the federal government, District of Columbia included, to restrict firearms. Left unanswered in that case was whether that right applied with equal force to state and local governments. And the McDonald case dealt with a ban in the city of Chicago on handguns. And the court, by the same 5-4 majority, there was one shift on the liberal side. Justice Souter had retired and was replaced by Justice Sotomayor. But essentially the same 5-4 breakdown occurred, and the Supreme Court held that the 14th Amendment did indeed extend the protections of the Second Amendment to the state and local governments. So that was an important case because obviously the vast majority of the gun control laws on the books today are enacted by state and local governments. Virtually every historian today believes that the 14th Amendment was designed in part to extend the protections of the Bill of Rights to state and local governments. People don't often realize it, but the Bill of Rights, the first 8 amendments to the Constitution, were really only designed to limit the power of the federal government and had nothing to say about what state and local governments did. That's why the First Amendment says Congress shall make no law abridging the freedom of speech. It doesn't say the state legislature in Massachusetts or the New York City Council. It says Congress because it was a restriction only on the federal government. But even though the framers of the 14th Amendment sought to extend those protections to state and local governments, the Supreme Court, right after the Civil War, held that the 14th Amendment did not extend those protections. And in a series of cases that historians now view as notorious for gutting the 14th Amendment, the Supreme Court denied really the promise of the 14th Amendment to we the people. When in the early 1900s, the Supreme Court decided, well, maybe some of these historians are right, maybe we should apply some of these provisions of the Bill of Rights to the states, they didn't know which provision in the 14th Amendment to look to. Earlier court decisions right after the Civil War had said that the privileges or immunities of citizenship were limited in their scope and did not include these basic Bill of Rights protections. And so the court used a different provision of that same 14th Amendment, the Due Process Clause, to protect these rights. But that was always very controversial. The Supreme Court has basically now incorporated virtually all of the Bill of Rights to apply to the states, not all of it, but most of the provisions in the Bill of Rights to apply to the states, and done it through the Due Process Clause. There was an effort in the McDonald case, an effort, by the way, that I was a part of. I signed a brief that made this argument, that argued it's time for the court to drop the Due Process Clause and to recognize the historical accuracy of understanding the Privileges or Immunities Clause to protect these Bill of Rights provisions. That the framers of the 14th Amendment, when they said no state shall deny to any citizen the privileges or immunities of citizenship, they were intending to refer to the privileges and immunities identified by the Bill of Rights. But the Supreme Court did not take us up on that. As usual, my argument loses in the Supreme Court. But in this case, there was only one justice who agreed that we should restore the 14th Amendment's Privileges or Immunities Clause to its rightful place. For most practical purposes, there's really no difference. I don't think that there was anyone suggesting that the court should radically rewrite the Constitution or radically rewrite most of its jurisprudence in interpreting the 14th Amendment, but just recognize that the court had been forced by circumstances, namely an early 14th Amendment case that had gutted the Privileges or Immunities Clause. The court had been required to look at the Due Process Clause. But it never really made much sense. The Due Process Clause says no state shall deny to any person life, liberty, or property without due process of law. But the court read that provision to protect substantive rights, even apart from due process. So you can't deny some rights, even if you provide all the process in the world. Well, that never really made much sense as a way of understanding the text. It says due process. It doesn't say you cannot restrict these rights. In fact, it seems to suggest you can restrict these rights as long as you have the appropriate procedures in place. But so the court had used this due process clause, but it had never really quite fit the history or the language. And in fact, I think part of the powerful criticism that conservatives have made over the years is that by interpreting this due process clause expansively to protect substantive rights, when the phrasing of the clause clearly indicates that it was designed to protect procedural rights, not substantive rights, that maybe by switching to the Privileges or Immunities Clause, we might restore a real historically accurate meaning to the Constitution, and one that would make sense. If I said to you that, look, the Constitution protects you in the enjoyment of your privileges or immunities of citizenship, the privileges or immunities, not language we use very often today, but what they meant by that were the privileges embodied in the Bill of Rights, it would be much, I tell you, it would make it a lot easier for me when I teach constitutional law every year to explain what the court's doing in these cases, because the textual provision would be that much more clear. I think the real difference is in it makes more sense of the Constitution. I don't think it necessarily makes a big difference on the ground in terms of what laws are constitutional and what laws are not constitutional. But from my perspective, it's important to get the history right in constitutional interpretation. I don't believe history is the be-all, end-all in constitutional interpretation, but I do believe it's important, and it's an important factor in how we understand what the Constitution means. And relying on a textual provision that doesn't really make any sense, I think discredits the process of constitutional interpretation and the method of constitutional interpretation. And providing a more sound footing would, I think, help illuminate for all Americans the breadth and scope of these constitutional rights. Well, to understand Justice Thomas's victory, I don't think it's much of a victory. He was one of the he was one of the majority voters in Heller case, but did not write the opinion. And he sided with the majority, but wrote his own opinion in the McDonald case. And in the McDonald case, he was the lone justice to support the idea that the Privileges or Immunities Clause should be reinvigorated rather than the Due Process Clause. So I don't see those cases as a great victory for Justice Thomas. To the extent they say anything about Justice Thomas, I think they show one of the things that Tubin was really getting at in that piece, which is that he's become a real intellectual leader on the Supreme Court, that he's much more consistent in his originalism and much more willing to bite the bullet on the hard questions than Justice Scalia is. Justice Scalia is the more famous originalist, but I think the majority opinion in Heller shows that in many ways he's not nearly as originalist as he claims, and that a living constitution idea really is embedded within so many of the important parts of the Heller decision. But nonetheless, I think because it was, at least superficially, a triumph of originalism, the Heller case, I think it definitely helps the cause of originalists more than it helps the cause of anyone else. So to the extent that Justice Thomas is a true originalist, then he's helped as well. There's no doubt that with the current conservative majority on the court, with Justices Scalia and Thomas being such strong proponents of originalism, and justices like John Roberts and Sam Alito having gone to law school and been among the early first movers in the conservative revitalization of originalism in the 1980s, that there is no doubt that originalism plays an important role in constitutional interpretation. And years ago, Justice Scalia used to say in his standard stump speech out there that you could shoot a cannon through the law faculty of any major law school and not hit a single originalist. And I think there's no doubt that today originalism is alive and well and has become a really important, if not the dominant way in which lawyers think about some of these constitutional questions. Thank you very much for having me.